My topic is the creation of the International Military Tribunal and the effect it had on the prosecution of the high-ranking Nazi Party members and officials during World War II. One of the most important events of World War II was the creation of the International Military Tribunal that charged and tried high-ranking Nazi Party members during the Nuremberg trials. This is important because it seized the rise of German power in the world and instead showed that the Allied powers were a force to be reckoned with. The trial of Nuremberg occurred at the Palace of Justice for both practical and symbolic purposes. It was large enough to hold mass amounts of people and had a prison on site. The city was severely damaged in Allied strategic bombings from 1943 to 1945. Nuremberg was a heavily fortified city that was captured in a fierce battle lasting from April 17 to April 21, 1945 by the U.S. 3rd Infantry Division, which fought household to household and block to block against determined German resistance, causing further urban devastation to the already bombed and shelled buildings. Despite the intense degree of destruction, the city was rebuilt after the war and was to some extent restored to its pre-war appearance. Nuremberg was considered the birthplace of the Nazi Party, where party rallies happened. Thus, it was a fitting place to bring about a symbolic end to the party. The International Military Tribunal was set up as a result of a choice deliberately made by the Allies between a number of alternative methods of proceeding against war criminals, which were open to them in 1945. They could have done nothing at all. They could have tried to assemble a court of neutral judges. They could have handed the whole problem over to the Germans themselves. They could, assuming they had decided to do the job themselves, have taken summary executive action instead of adopting the more elaborate methods of legal proceedings. The idea of the trial before judges, drawn from neutral countries, has a superficial attraction for the cultivated mind, but it is a baseless charm. In the first place, no such court existed, and it would have been very difficult to constitute and assemble one with reasonable expedition. The Allies went ahead steadily with their plans, both military and legal, in accordance with agreements reached at the Yalta Conference and instructions based by the late President Roosevelt. The United States of America formulated and proposed international agreement on the trial of the war criminals, which was submitted during the San Francisco Conference to the foreign ministers of the United Kingdom, the Soviet Union, and what was then the Provisional Government of France. Subsequently, and after many modifications, the proposal became the charter, or basic law for the tribunal, which Jackson was then addressing. The law had not been codified, no procedures had been established, no tribunal was in existence, no usable courthouse stood here, none of the hundreds of tons of official German documents had been examined, no prosecuting staff had been assembled, nearly all the present defendants were at large, and the four prosecuting powers had not yet joined in common cause to try them. It is true that the London Agreement is more explicit in declaring aggressive war to be a crime than any preceding international document. This may be because greater explicitness was required in a legal document than in a diplomatic undertaking. It may be because the London Agreement represents the work of jurists and lawyers rather than diplomats. In the negotiations, the United Kingdom was represented by the Lord Chancellor and the Attorney General. The Provisional Government of France appointed Judge Robert Falco of its highest court, the Cour de Cassation, Soviet Russia, and I.T. Novichenko, Vice President of the Soviet Supreme Court, as well as the President of the United States, who was Commander-in-Chief and participated on behalf of the United States in establishing the International Military Tribunal. Whatever the state of law has been, such conduct is a crime now. When representatives of the four nations, the United States, the United Kingdom, Soviet Russia, and France, set their signatures to the agreement on August 8, 1945 in London, the old order by which all was legal visibly passed away. The London Agreement only recognized an evolution that already had been consummated. 19 nations apart from the signatories have now adhered to that agreement. It represents the consciousness of opinion and judgment among the greater number of civilized nations. The tribunal has decided that certain of the defendants planned and waged aggressive wars against 12 nations, and therefore guilty of the series of crimes. If the trial itself proved to deserve that very discredit and no condemnation that were heaped on the German leaders, then the basis of the claim in reparations would be gone, and that claim would in turn lose its justice. The United Nations wished to proceed in a more civilized way, so the victors provided for indictment and trial. They wished to give the accused every reasonable opportunity to disprove by documents and witnesses. The charges is formally drawn and as supported by an overwhelming mass of evidence. Even notorious criminals caught red-handed ought, in a civilized polity, to be given an opportunity to explain and defend. Consequently, Section 4, Article 16 of the Charter of the International Military Tribunal, which is entitled Fair Trial of Defendants, provides for the giving of detailed particulars in the indictment, the furnishing of the indictment and all apartment documents in appropriate translation to the accused, the permitting of the defendant, during preliminary examination or trial, to give any relevant explanation of the charges, and the translation of the examination. Another issue that arose during the trial, before and after, was the legality and ex post facto laws that German people and lawyers had brought up. On November 21st, 1945, the statement made by the Counsel of the Defense at the opening of the Nuremberg trial, the claim was insistently urged that to hold the accused as individuals for acts of the state was ex post facto and unjust. It is notorious that a great deal of clear and serious ex post facto legislation was enacted or decreed in Nazi Germany. For example, whoever commits an act which deserves punishment according to the principles of criminal law and to the sound feelings of people will be punished. One can understand the spirit with which in domestic constitutional law the application of the ex post facto test to legislation is jealously insisted upon, for it rightly concluded that the antagonism to ex post facto laws rests upon the sound principle: if the law can be created after the offense, then power is absolute and arbitrary, but the essence of the doctrine in question, as applied to a novel situation, can only be grasped when one views the actual effects upon the person accused of crime. It is unjust to punish for an act which prior to the commission was not officially prohibited, because to do so would change arbitrarily the legal consequences of an act. Reviewing the historic facts, it becomes abundantly clear that the Nazi leaders knew that Germany's numerous unlawful and unprovoked assaults upon her peaceful neighbors constituted wars of aggression. The wars of aggression have been outlawed by the action of the great majority of civilized states, including Germany, Italy, and Japan, that several international pronouncements had declared such deeds to constitute specifically international crimes, and the United Nations were in no way limiting themselves with reference to the type of acts they would regard as war crimes, but, on the contrary, were not unlikely to include the planning and waging of aggressive war among the criminal acts for which individuals would be held responsible. Summarizing the historic evidence and authority correctly concludes: in any form of society, the conduct of men in forming legal relationships is governed by customary rules. These are recognized and followed as law independently of any sovereign injunction or enforcement. Internationally organized society is still in such early forms as of today. In acting jointly and as an agent of all civilized states in vindication of international law through the prosecution of individuals who brought about its wholesale violation, the United Nations needed no pre-existent world state or world legislation to justify the jurisdiction. The agreement of the Allied States during both World Wars I and II to pool their rights and duties in the enforcement of international law as agent for the entire family of nations was in itself an exercise of world sovereignty in behalf of world law. Any formal charter of united action could only have been declaratory for an existing situation.